First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have two cases on the docket today. We'll take them in the order they appear. The first case today is UMB Bank versus Florida Department of Transportation. Counsel, if you're ready, you may proceed.
May it please the court, Elliot Shirker on behalf of UMB Bank. With the court's permission, I'll reserve 3 minutes for rebuttal.
So noted.
The Santa Rosa Bay Bridge Authority's bonds went into default in 2011. The debt was accelerated in 2013. The bonds remain in default. The bonds are payable from and secured by toll revenues, which revenues indisputably have been inadequate to pay the principal and interest on the bonds. The authority is required by Section 5.02 of the bond resolution to establish adequate tolls. But the authority has been defunct since 2014 after a traffic study recommended significant toll hikes and the authority refused to act. The lease purchase agreement in Section 1.04 requires FDOT to act on tolls if the authority fails to perform its obligations. The trustee notified FDOT in 2015 that the tolls were inadequate to repay the bonds pursuant to an expert study. FDOT refused to raise the tolls despite the study's findings, and despite a 2017 legislatively mandated feasibility study's finding that FDOT was legally obligated to raise the tolls to fund the bond payments and likely would be sued if it failed to do so. A 2019 study that recommended significant toll increases, and a December 2019 summary judgment on FDOT's counterclaim, a judgment that FDOT has never challenged before this court, in which the trial court ruled that FDOT is legally obligated by Section 1.04 to establish tolls as recommended in the 2019 report, because the authority has failed to do so under Section 5.02 of the bond resolution. And it took the trial court's February 2020 order compelling compliance with the counterclaim summary judgment to get FDOT finally to raise the tolls. But now FDOT says it's years of delay in complying with LPA Section 1.04. Indeed, its prior denial of any obligation to raise tolls is of no moment, and that FDOT should essentially get off scot-free for damages caused by that delay. The trial court agreed, and that's what brings us here today. To start at the beginning, the question is whether bondholders can be heard to assert a claim for breach of the LPA. And the answer must be yes for several reasons, all arising from unambiguous contractual language. First, under LPA Section 1.04, FDOT and the authority adopted Section 5.02 of the bond resolution, quote, for the benefit of the bondholders, and guaranteed that the revenues would be sufficient to service the bonds. Second, Section 3.03 of the LPA states, quote, the LPA shall be deemed to have been made for the benefit of and shall be a contract with the bondholders. It further states in Section 3.03 that the department and the authority, quote, consent to the bringing of any proceedings in any court of competent jurisdiction in the state of Florida by any holder or holders of bonds for the enforcement of any and all covenants, terms, or provisions of that agreement. And third, although Section 3.22 of the LPA states that the bondholders may enforce by specific performance as third-party beneficiaries, Section 3.23, the very next section of the LPA, specifically states that, quote, no remedy conferred upon or reserved to the authority, the department, or the bondholders, quote, is intended to be exclusive of any other available remedy or remedies, but each and every such remedy shall be cumulative and shall be in addition to every other remedy given under this agreement now or hereafter existing at law or in equity or by statute. The first amended complaint and the currently operative second amended complaint plead a claim for damages arising from FDOT's long-lasting breach of Section 1.04 to make the bondholders whole, which specific performance going forward by definition cannot do. This is not double recovery, nor is a claim for damages barred by the election of remedies doctrine. If FDOT abides by the trial court's orders compelling performance, the bonds may eventually be paid off, but much later in time than was contemplated when the bonds were put on the market. That's the basis for our incidental damages claim, as we explained to the trial court. Under well-established precedent, contract damages are not inconsistent with equitable relief. Both remedies affirm the contract, so pursuit of one remedy cannot waive the other remedy.
But aren't the damages you're seeking, aren't they also inconsistent with the bond offering statement? The offering statement itself just suggests and states very plainly that the bonds are special limited edition revenue bonds of the authority and shall not constitute an obligation of the state. There's other language in the bond statements that are consistent with that.
Yes, ma'am.
So how can it be that there are damages arriving from non-payment of the bonds that are anything but repayment?
The revenue for payment of the bonds, repayment of the bonds, comes from toll revenues. Of course it does. It's guaranteed by the bond documents. It's under the LPA. It's repayable in the ordinary course from the bond revenues. But we're not seeking payment of the bonds. We're seeking damages for FDOT's breach of a contract that obligated FDOT in no uncertain terms to provide for toll revenues that were sufficient to repay the bonds. We not only lost 5 years of adequate bond payments, we lost it, as we explained to the trial court at the summary judgment hearing, we lost the use of that money during that period of time. We lost reinvestment opportunities. For that matter, the bonds mature in 2028. The bonds are undisputedly not going to be paid off by 2028, which leads to further incidental damages. FDOT breached a contractual obligation that we are entitled to enforce. And there's nothing in the documents that says, as to the bond repayments themselves, that FDOT couldn't raise the revenues from the tolls to cover that particular aspect of the damages. Your Honor, it's almost like we're at the courthouse door saying, please, may we come in to plead a breach of contract claim, and the party on the other side says, well, there's no money from which you can collect because these are revenue bonds and not general obligation bonds. We haven't even reached the question of trying our damages claim. We're talking about collection when we're still having the courthouse door slammed in our face. So although the bonds are repayable only from toll revenues, our damages are our damages. And we're being cut off before we can even get a chance to present those damages to a jury. And again, I return to Section 3.23 of the LPA, which specifically provides that all remedies are cumulative, which is completely in accordance with common law. There's nothing inconsistent about seeking a recovery of damages by affirming the contract with specific performance in affirming the contract. And of course, the law is very clear that one does not waive an available remedy unless the contractual documents specifically state that all other remedies are waived. To the contrary, these contractual documents state that all remedies are available. So because the bridge bonds are revenue bonds and not general obligation bonds, the trial court ruled the trial court essentially, as I said, slammed the courthouse door in our face and said we can't go forward with our claims.
Counsel, if you had, if the authority were not defunct, could you bring the same action in the same way against the authority?
If the authority had refused to raise the toll revenues, yes. FDOT stands in the authority's shoes.
And your remedy there is raising the tolls?
Well, our remedy going forward is for them to do what them, meaning the authority and or FDOT, to do what the contract obligates them to do, to provide for toll revenues sufficient to repay the bonds. But we had about 5 years in which we requested FDOT to raise the toll revenues, in which FDOT was presented with expert study after expert study and simply told us
right.
to pound sand.
What I'm asking is, that, so the authority has limited financial revenue, right? It's only from the tolls.
Right, that's correct. The authority's revenues from the tolls.
So if the Department of Transportation is stepping into the shoes of the authority, are you not stepping around that what would have otherwise been the nature of the authority's ability to remedy the action by reaching into a new source?
No, sir, not at all, because the department has its own obligations independent of the authority. The department is obligated to act if the authority does not. The department is obligated, its denial of that obligation notwithstanding for so many years, to raise the revenues so that they're sufficient to repay the bonds. And the department refused to do so even after a summary judgment was entered on that, and it required a court order enforcing the summary judgment to do it. So the department has its own. The question about the department's obligation, Your Honor, I guess what I'm trying to say has already been settled by the summary judgment on the counterclaim. The department is obligated to provide for sufficient toll revenues to repay the bonds, period. That's not even before the court as a question. So now that we know that there's an obligation, we know that obligation was breached, we're coming forward with a claim for damages from that breach. This is a contract case. This is at its heart a very simple contract case. The contract is unambiguous. The bondholders are entitled to bring an action. The bondholders are entitled to all available remedies under Section 3.23. And the department is saying, let's stop right here because these are only revenue bonds and not general obligation bonds. So we cannot be held liable for the undisputed breach of contract for a period of 5 years. You're going to get your money someday, not in 2028 when the bonds mature, but you'll get your money on the bonds someday. But the loss of the use of that money, the reinvestment opportunities that were lost, the reinvestment opportunities that will be lost after 2028, we get off scot-free for that. The contract cannot be read to allow that. It's that simple. It's a straightforward reading of the contract and straightforward obligations that the department breached under the LPA. I'll reserve my time for rebuttal. Thank you very much.
May it please the Court, Mark Peoples for the Florida Department of Transportation. The bondholders made an investment. They were apprised of the risks, they were notified of the limitations, and they made an investment. And so far, that investment hasn't paid out as they had hoped. The bondholders are now asking the department, and by extension the taxpayers of this state, for a bailout. To my mind, this is a paradigmatic example of privatized gains, socialized risk. The trial court wouldn't condone it, and neither should this court. One thing I'd be remiss if I didn't point out is that even if, as the bondholders' counsel would have it, somehow the full faith and credit of the state is intended as a backstop for these risky investments, the department did not issue these bonds. The authority did. The department's role here was to operate and maintain the bridge. The authority sold the bonds. The authority sold the bonds to finance its construction, its operation, and other expenses. The arrangement was that the department would, as part of its operational responsibilities, would collect tolls and disperse them to the authority, who in turn, pursuant to their contractual arrangements, would disperse them to pay down debt. And once the debt was paid down, the department would be reimbursed for the operation and maintenance expenses that it's incurred. The department hasn't been reimbursed a dime. I have the latest figures. They're not of record because they are the latest figures that I can share with the court, but they are substantial. And we have not been reimbursed one dime for our operation and maintenance expenses.
Well, counsel, if you could, let's turn to the language of the lease purchase agreement. And it seems to me that the bondholder's best argument is that there seems to be some tension between 3.22 and 3.23. So 3.22 on the one hand states that the contract shall be enforceable by specific performance and that no other remedy at law is adequate to protect the interests of the parties and the bondholders. And then in the next section, it then states, no remedy conferred upon or reserved to the authority of the department or the bondholders is intended to be exclusive of any other remedy. So why is it not the case that the bondholders could seek specific performance and then damages for the loss of the use of the funds for 5 years?
Well, okay. There's a couple of responses to that. First, Mr. Shurker got started on the contractual language which provides that the bondholders are intended third-party beneficiaries per the contract. But he didn't address the implications of that. What does that mean? What that means under the law is third-party beneficiaries, their rights are derivative of the contracting parties. They stand in the shoes of the contracting parties. Their rights cannot exceed the contracting parties' rights. Mr. Shurker told you, and I agree, that under the contract, the authority is charged with raising tolls. The authority could not sue the department for not raising tolls when the authority thought that they should be raised. And because the bondholders purport to stand in the shoes of the authority, neither can the bondholders. I've not heard them yet address exactly how they purport to stand in the shoes of the authority, yet maintain a claim for damages that the authority could never bring.
But you don't quarrel with the fact that specific performance was appropriate here?
No, I don't.
Not even as to the third-party beneficiaries?
No, the contract, I read that language in 3.22, the specific performance clause. I read that language to waive the defense to a specific performance claim that you have an adequate remedy at law, you can just get money. Indeed, when they sued us for specific performance, we didn't raise that defense. But just because you can sue for specific performance does not mean you can also seek damages. Damages and specific performance are inconsistent. This isn't a contractual matter. This is not a matter of a conflict between 3.22 and 3.23. This is a matter of election of remedies. And under the common law, if a specific performance claim is taken to judgment, and this was, we have an order, you all discussed it with appellant's counsel, requiring the department to raise tolls. If that's taken to judgment, then an inconsistent remedy, such as damages, is unavailable. That's under the common law, not through some conflict between 3.22 and 3.23. And one other thing I'd point out is that the nature of their damages claim. And I think that Judge Long was getting into this when he was asking, if you would sue the authority's only source of revenue would be the tolls. So is this not an end around that limitation? Their complaint seeks damages in the form of what they call forfeited tolls. They define forfeited tolls as millions of dollars in higher tolls that were lost and could and should have been collected and paid to plaintiff for the benefit of the bondholders. That sounds a lot to me like damages would go to pay the bonds. I don't know another way to read that language. That there's seeking money that is not toll revenue to pay down the bonds. And as you pointed out, Judge Rowe, the offering circulars and the contracts are surfeit with references to the bonds must be paid solely from toll receipts. Nothing in the bonds or the bond resolution shall be construed as obligating the full faith and credit of the state.
Well, what do you make of the bondholders' argument that you could raise the tolls even higher to compensate them for the other damages that they're seeking?
Well, there's a sliding scale, right? And if both the department's traffic consultants report and their consultants report are of record, but there is a sliding scale of demand and setting the toll. As you raise the toll, demand goes down. And so, sure, we could raise the toll to $33 million and just have one person drive through the toll, and all of a sudden we're reimbursed for our expenses. But that's I don't think that that's quite what I don't think that's a realistic option. We right now, and there's no dispute about this, all toll receipts are paid to the bondholders, every dime. Again, the department hasn't received one dime for its expenses, one dime for its operation or maintenance expenses. It's simply going to take longer than the projections had hoped.
Did the department make any counterclaim for those expenses?
Well, no, because the bondholders don't owe us the expenses. The authority owes us the expenses after the bondholders are made whole. We're not there yet, and we won't be there for quite some time. Anticipating that they may contend that the summary judgment on the counterclaim didn't quite satisfy their specific performance claim. I want to point out a couple of things. They moved to dismiss the counterclaim. And one basis for their motion to dismiss, this is a record 533 through 535, they specifically argued that the counterclaim raises the same issues that will be determined in the specific performance claim. And then at the hearing transcript on this summary judgment motion, the trial court, I think, was a little confused as to whether the judgment on the counterclaim was satisfied their specific performance claim. I think that one counsel for UMB said that no, that all that was at issue was the counterclaim, not the count one, not the specific performance claim. But the trial court at record 3834 referenced an agreement between the parties that whether FDOT was responsible for raising the tolls would be decided on cross motions for summary judgment on the department's counterclaim. Counsel for the department confirmed that that was his memory, and counsel for UMB didn't object. So, and really the practical effect, which the specific performance claim said raise tolls, and the judgment on the counterclaim said raise tolls. Again, the law looks to substance, not form, and in substance, the specific performance claim was granted.
Counsel, let me ask you a question
Yes.
to sort of maybe take us back to basics just a little bit. So you have the authority is issuing these bonds. They have this limited revenue source, and I get all of that. But DOT also participates in this process and agrees to take on some responsibilities. And to your point, as you began about privatized profits and
Right.
socialized risk,
Right.
that sort of thing. At the same time, though, the Department of Transportation has accepted some responsibility to carry out some functions, and they've failed to carry out those functions. Is your position that they can't be held responsible for that other than the specific performance? And you're reaching that conclusion just by the limitation of the language, the enforcement obligations provision? Not
just from that, but also I continue to stress that as third-party beneficiaries, they're standing in the shoes of the authority. The authority could not sue the department for not raising tolls. They purport to arrogate to themselves a right the contracting party would not have against the department. That, as far as I can tell, that point's never been answered. Their answer in their brief, when we raised it in the answer brief, was essentially, no, as third-party beneficiaries, we have the right to sue the department.
All right, well,
But
you're
we've never
acknowledging-
questioned whether they have the capacity or standing to sue.
You're acknowledging that they have the ability to seek specific performance, though they already have, and that's been done, right?
Yes?
So my question is, recognizing that the Department of Transportation has agreed and taken on certain responsibilities, is the specific performance of raising the tolls the only possible way to hold the Department of Transportation accountable for their failure to comply with the terms of the agreement?
Okay. First, I don't concede that we did fail to comply with the terms of the agreement. It's true that the trial judge entered summary judgment, a non-final order of summary judgment on the department's counterclaim, but the department reserves the right to appeal that order on plenary appeal. So I can't agree with the premise of that.
Fair enough.
But I think your question is, assuming that this court does affirm that counterclaim summary judgment, is specific performance the only remedy that they have under the contract?
Yes.
Yes.
And that's based on your interpretation of these contractual provisions, excluding any other available remedy.
No, it doesn't have much to do at all with 3.22, the interplay between 3.22 and 3.23. It's because the damages that they seek are from toll revenue, or rather from revenue that is not toll revenue. But the damages that they seek are expressly for tolls that were lost and should have been collected and paid to the bondholders. Under the contract, the only available revenue to be paid to the bondholders is toll revenue. To reach outside that to general revenues would make the department a guarantor of this risky investment. That's not what the contract does. The trial judge so found, and this court should affirm. If there's no further questions, I think that I'm out of time. I ask the court to affirm. Thank you.
Thank you, counsel.
May it please the court, I believe I heard my opponent say that we should lose because the authority can't sue FDOT to raise the tolls, and we're only third-party beneficiaries. It would never happen under these documents that the authority would sue FDOT, because FDOT's obligation to raise the tolls only kicks in when the authority refuses to do so. And at that point, Section 3.03 of the LPA kicks in, because Section 3.03, as I said in my opening argument, this is from the record at 3435, is 3.03 is where the department and FDOT, the department and FDOT, consent to the bringing of any proceedings for the enforcement of any and all covenants, terms, or provisions of this agreement. So our dispute with FDOT only arose when the authority refused to do its job. We're not merely third-party beneficiaries standing in the authority's shoes at all. I also heard my opponent say that FDOT did not issue the bonds, which is sort of a neither here nor there so far as I understand these documents. FDOT, under the LPA, assumed certain obligations. I heard lots of complaints about how FDOT hasn't been repaid for all of its expenditures on the bridge. FDOT is going to be repaid for its expenditures on the bridge after the bondholders are made whole, and that's expressly in the LPA. Judge Rowe, you're entirely correct. We have no obligation as the bondholders to pay for the maintenance of the bridge. That's FDOT's obligation under the LPA. And what does FDOT get at the end of the day? FDOT gets the bridge. It's a lease purchase agreement. FDOT gets the bridge at the end of the day. That's its ultimate benefit. And at that point, FDOT is collecting the tolls and can apply that money to the maintenance of the bridge. That's exactly the way the agreement was structured from the very beginning. This is a purely contractual case. There's no inconsistency between the specific performance obligations that we enforced and the damages that we seek to recover. We are not in our complaint saying, just to be very clear, what you heard Mr. People say, we are not saying that our damages are recoverable from any particular source. We are not saying that our damages are recoverable based on the full faith and credit of the state of Florida. We are saying that FDOT, and you basically heard an admission, FDOT breached the contractual obligations and is liable in damages for those obligations, and they are not solely toll revenue obligations. They're the loss of money over 5 years, loss of money and reinvestment opportunity over 5 years that adequate tolls were not collected, despite our repeated invocations of the LPA, despite our repeated requests.
Is the only source of damages or payment of damages toll revenue?
The only source of payment of the bonds is toll revenue.
But what about from the department? If we were to agree with you, and if damages were available, where would they be paid from? Would it be toll revenue? It certainly can't be the general revenue, full faith and credit of the state of Florida.
Your Honor, I don't know, as I stand here, ultimately where the damages would be recoverable from. That would be a matter for the trial court to decide in enforcing any judgment for damages. But let me be clear about what 3.22 states, because I think it was being overread during my opponent's argument. What 3.22 states is that the covenants and agreements hereunder, including specifically the obligation of the department to ensure, operate, maintain, and repair the Series 1996 project, and to collect and deposit the tolls, in accordance with the terms of this agreement shall be enforceable by specific performance. We invoked specific performance to compel the department to collect and pay the tolls. That doesn't say, especially in light of 3.23, that our damages that were incurred during the period of time that FDOT was not collecting the tolls, our incidental damages, are not payable from the general revenue of the state of Florida. It doesn't say that because we're not paying the bonds by collecting those damages. But again, we're at the courthouse door with a claim for damages. And FDOT is saying, you may not be able to recover those damages from general revenues, therefore you don't have a breach of contract claim. And respectfully, that's like saying in a private contract dispute, I'm bringing a claim for damages, and the defendant saying I'm entitled to dismissal because I have no assets, all my assets are in my corporation's name, all my assets are in my spouse's name, I have no assets from which you can recover, and therefore your claim should be dismissed. That's not the law of Florida, and that shouldn't be the law when the department is acting in the same capacity as a private individual and agreeing to undertake certain important contractual obligations.
Okay, thank you, counsel. Your time has expired.
Thank you, Your Honor.
And thank you both. Good afternoon. Our second case on the docket today is John Dominic Iarussi versus Sarah Michael Iarussi. Counsel, when you're ready, you may proceed. Sure.
May it please the court, Shannon Novi on behalf of the appellant, John Iarusi. I'd like to reserve 3 minutes for rebuttal.
So noted.
The issues at trial in this appeal involved 3 things. 1, what was the fair market value of a company called Lobby Tools? 2, the wife's claims to retroactive and prospective alimony. 3, the wife's claims and the husband's defenses to entitlement to attorney's fees. Nothing else. At trial, the experts were $3 million apart with regard to the value of Lobby Tools. The court, after a year after the close of evidence and about a year and a half after the beginning of evidence, entered a 101-page order that was contained 95 pages approximately of verbatim adoptions as submitted by the wife's counsel. In doing so, the court awarded the amount of Lobby Tools based on the wife's expert's valuation over a Daubert objection, and that resulted in about $1.7 million to the wife. In addition, the court awarded 6 years of alimony and 31 months of retroactive support for a total of 8 years and 7 months of support in a marriage that was just under 15 years long.
Could you clarify when the trial court, and you're using the term retroactive alimony, which bucket does that fall in? Was this the temporary alimony? Was this durational? What category of alimony under the statute is this retroactive alimony award?
So there was an agreement among the parties for certain pieces of the time, but the court has the ability to award alimony retroactive to the petition date under the statute, and that's what the court did here. But when the court does that, it's required to make findings, all the same findings in 6108 that are required for alimony going forward as it is for alimony that's applied retroactively in the past. So need, ability to pay, consideration of all the financial resources.
Right, but what type of alimony is it? And that's because each of those different types of alimony have statutory factors that have to be applied to determine whether that type of award is appropriate. So is this durational alimony that was applied retroactive? Or?
I think that's the only thing you can call it.
Okay.
But I frankly don't know how the court conceived of that because it didn't tell us in its final order that it adopted from the wife. It just said, I'm going to award alimony retroactive, so going forward for this amount of time and retroactive for that amount of time.
If we can't tell from the order or the transcript what type of alimony that is, how can we review whether there is an abuse of discretion in the award?
I think what the court has to do is look at the factors in 6108 that apply both retroactively and prospectively, Your Honor. So what that means is, what is the need during the relevant time period? What is the ability to pay during the relevant time period? And how do all of the other factors in 6108, 2A through J, apply at each point in time? So to the retroactive amount and then going forward prospectively. In some circumstances, a verbatim adoption of an order can be okay, doesn't have to constitute error. But the adoption here.
Let me ask you about that issue, if I may, Ms. Novi. The cases seem to be everywhere. What is the algorithm here? What is the test for us to discern whether there was independent judicial labor by this judge? It is concerning that so much of this is adopted verbatim, but what is that test for us to apply?
Sure. So thank you for that, Your Honor. The test is kind of threefold, but two of them overlap, okay? So is the signed judgment inconsistent with the trial court's earlier pronouncements? And I'm going to talk to you about errors that would fill that bucket, okay? And then is there the appearance of impropriety that justifies some sort of suspicion of unfairness? and that one has to do with, I think, the time element, but it's not just the time element alone. So the 17-month delay of, in this case, the final judgment, the supplemental final judgment is problematic where there's an indication that something's amiss. Well, there's an indication that something's amiss because we have a judgment that's inconsistent with the court's earlier pronouncements, and also that the record establishes that the judgment doesn't reflect the judge's independent decision-making on the issues. Let me give you some examples. Exhibit 188 was a lifestyle analysis relative to the wife's alimony award. The court relies on that exhibit. The court rejected that exhibit at trial, then said, I'm going to hold on this and some other exhibits, but relies on it on page 92 of the judgment and then excludes it from evidence 7 pages later. Similarly, exhibits 227 and 228, not admitted at trial, and there was an objection that was raised as to their improper disclosure under the court's pretrial order and under the case law. The court sustained the objection with regard to 2 rebuttal witnesses, didn't rule or allow into evidence those 2 exhibits that I just referred to, said I need to think about that, and then entered a supplemental final judgment that is totally contrary to the court's reasoning with regard to the exclusion of the rebuttal witnesses in admitting those 2 rebuttal exhibits, said in the order it was neither prejudicial nor a surprise to Mr. Iarussi, but in fact it was both. It was incredibly prejudicial to Mr. Iarussi because despite the fact that Mr. Lugar, the valuation expert, did not rely on those exhibits, and counsel for the wife said, I'm not submitting calculations relating to these exhibits into evidence, the court then adopted a footnote that contains a calculation by counsel that wasn't submitted into evidence into its order. So these are indicia that the court did not exercise its independent thinking and judgment in entering the order that it did.
Let me ask you, and I appreciate the argument. It's well elucidated in your briefing, but the issue you just brought up, separate and apart from the bigger issue, is that a radioactive issue too? I mean, the fact that you've got this overt inconsistency between the trial ruling and you're allowing in evidence that has been excluded and shouldn't be part of this judgment? Is that a bad enough thing to radioactively take out this judgment? I'm just asking.
I think of the verbatim adoption issue as really a basket that, but for the errors, this one that we're talking about now, and the other errors that are contained within the judgment, that it holds all of those errors. And I really think that the most fundamental error that the court made in adopting this judgment related to the Daubert objection and its overruling of the objection that was lodged in a motion in limine with regard to the testimony of Mr. Lugar. Because the essence of Daubert, and really this appeal with regard to the verbatim issue, is show your work. Show your work. And the trial court improperly admitted testimony from Mr. Lugar over that Daubert objection when it did not and could not comply with his own professional standards.
But isn't that just, that's a legal disagreement, right? I mean, you disagree with the trial court's conclusion on the Daubert issue that was litigated and argued, and trial court reached a conclusion you disagree with. Is that a trial court disagreeing with you certainly isn't necessarily an indication that the trial court didn't independently use their judgment in reaching that conclusion, right?
So 2 things there, and let me sort of separate them for you, Judge Long. The court has discretion to evaluate the credibility of the witnesses, both lay witnesses and expert witnesses, of course. But that discretion is circumscribed by its proper application of the law. So you cannot properly exercise discretion when you have misapplied 9702, which says pure speculation cannot stand in withstand a Daubert challenge, and that has long been the ruling of this court. Mr. Lugar was deposed, and he also testified at trial on a number of very important valuation issues. His answer was, "It's my professional opinion." He said that with regard to his narrowing of somehow of the values that he found from somewhere between $4.5 million all the way to $16.3 million. When asked, how did you arrive at a precise value of $6,368,000, he said, that's the number that I came up with, in my professional opinion. I didn't do any math, I didn't apply a formula, and that should have been excluded pursuant to the law, and there couldn't be a proper exercise of discretion about that. So if you look at pre-Daubert cases from this court all the way back to 1993, there's a Sunbank v. Edmonds case. The issue in that case dealt with fair market value of a utility, and the expert in that case adjusted the fair market value in arriving at his opinion without the use of a method or formula, and instead said that it was based on his familiarity with the subject entity and that his opinion was a matter of judgment. This court reversed that allowance of that testimony with instructions to enter a new order based on the testimony of the competing expert, which is what should happen here. You can exercise professional opinion, but you can't do so without explaining to the court why the experience is a sufficient basis for the opinion, how the judgment was applied to the facts. And so that's the essence of Daubert. No more black box accounting. There are other cases that are outlined in our brief on this matter that relate to the comparables. Mr. Lugar, in arriving at that bracket number of $16.3 million compared to his income-based number of $4.5 million, relied on companies in Slovenia, in Denmark, in London. None of those companies are comparable, and the court in Samter, which is a third DCA case, has said that we cannot permit a witness to relate sales that are obviously not similar to the subject entity and then shoehorn in, based on those non-comparable comparables, a value that the court can accept. I see that I'm well into my rebuttal time, so I would ask the court to reserve for the remainder.
Thank you, counsel.
Hi, good afternoon. My name is Linda Bailey, and I am here to represent Sarah Michael, who is the former wife. She's also the former CEO and COO of Lobby Tools since 2015, and she was the president of Lobby Tools from 2006 up to her taking over the role as CEO in 2015, and the valuation date of Lobby Tools was April of 2018. What Mr. Iarussi is asking this court to do is to set aside a 101-page, very detailed and cited final judgment entered after a 6-day, very complex trial without any record evidence that the court rubber-stamped the proposed order that
Isn't the record evidence the evidence of what was submitted to the court and what was actually signed? Isn't that the record evidence? I mean, it's right in front of us, is it not?
Correct. There is no evidence that suggests that the court did not use her independent judgment or that she rubber-stamped this final judgment. This final judgment that the court entered after a lot of thought and in compliance with the Supreme Court rules that you inquired about earlier made significant changes to the proposed order that we sent.
So those changes are to findings of fact? I mean, in looking through it, it looks like most of that, if not all of that, was just rubber stamped.
No, sir. Actually, what the court did as far as making changes is they changed Ms. Michael's finding of need significantly. They removed any mortgage payments for Ms. Michael. They removed major standard of living components to her need. They reduced the retroactive and prospective alimony by over half. They reduced the duration of the alimony by 9 years. They reduced the total reduction in alimony from the proposed final judgment was, I believe it was over greater, the change was $1.7 million less than we had asked for, because we had asked for a need based on the standard of living during the marriage. It appears that the court granted that need more based on the separation period. We didn't appeal that. That's not before the court today.
And thank you for that answer, Ms. Bailey. I'm going to pivot.
I'm sorry?
I'm going to pivot off that question I just asked you, though. I am very interested in prejudgment interest. First, where does prejudgment interest come from in this case? Because as best I can tell, it's not pleaded, it's not part of the pretrial stipulation, it's not mentioned at the final hearing, and the first mention, it's not mentioned in the partial marital settlement agreement, and the first mention of prejudgment interest is in your proposed order to the court, just almost at a whole cloth. So where does it come from?
Your Honor, in accordance with the Mobley case, it does not have to be pleaded. It's a ministerial act.
Well, you would agree it's a common law of damage, or it's a component of compensatory damages, is it not? I'm just reading from your brief. I think your amended answer brief says that. It's an element of damages. You would agree with that?
Well, it's an element of equitable distribution in that when the court determines the date of entitlement and the valuation as of that date, was that party kept from any sort of benefit from that benefit of that asset during that period of time.
You said it's an element of equitable distribution. Is it in? I didn't see it mentioned in the equitable distribution statute.
Yeah, the Mathers case, which is a 2009 4th DCA case.
No, I know the cases say
Okay.
it. I know the cases say it. I just don't see it in the statutory language. I just don't see that term, prejudgment interest, anywhere in the equitable distribution statute.
It is not. It is not, Your Honor. It is what I see in the case law. And when you look at the Carney case, which was cited by Mr. Iarussi, the difference in that case was there was one trial and then there was a second trial. Just before the second trial, the Carneys entered into a marital settlement agreement. What had happened in that case is she was already provided distributions, and then she asked for pretrial interest as well. So during the period of time from valuation to the settlement, she had received distributions, and then she was asking to receive interest on top of that. So it would have been basically double counting, where she would have had the benefit of not only the distributions, but a pre-judgment interest as well. And that's not the case here. Here, the situation was after April of 2018, Ms. Michael did not receive any benefits of the company. She didn't receive, during that 3-year period of time, any distributions based on her entitlements, where Mr. Iarussi, based on normalized profits, received almost $1.9 million in company profits and distributions that would have been marital during that period of time, from date of valuation to the date it was actually quantified.
I mentioned earlier the Pmsa, and I'm looking here, I don't know if you have it in front of you, 9.03, that this section actually referenced, certainly in the reply brief, intimated in the initial brief, about mutual release. And as I read this Pmsa, I see we've settled everything. We're going to reserve 3 items. But if there's anything else, anywhere else, any claim, any action, that's been waived. Tell me how I'm wrong about that.
Okay.
And I see that right in 9.03.
Okay. Because the prejudgment interest is also, it's part and parcel of that equitable distribution and the valuation of lobby tools. We agreed on an entitlement date, which is the same date of valuation. I think those are equivalent concepts, which is April 13th, I believe it was, 2018. And we didn't have an adjudication until almost 3 years later. In the Pmsa, we also have the following language. The Pmsa reserved the jurisdiction to value and distribute equity and lobby tools, set the valuation date as of the date of filing, and reserve to, quote, resolve any matter subject to the jurisdiction of the court that has not otherwise been resolved by the terms of this agreement. So there was no waiver of pretrial interest, and it's much different than the language that you see in the Carney PMSA, where there it was clear she had no entitlement because she waived in her PMSA all entitlement to past, present, and future benefits or distributions from Mainline.
But the recurring term, and I'll use the word term, 3 words, valuation and distribution. I see that recurring all through the PMSA. Where in valuation and distribution is there a prejudgment interest? I just don't see that. Are you saying it's subsumed within distribution?
I'm saying it's inherent in the process of valuing an asset which provides benefit when you have to backdate that valuation. So, in this period of time, we had from 2018 valuation date, we didn't finish trial until spring of 2020, and then we had a final judgment early 2021. So here we have almost 3 years of my client not having any benefit of an entitlement that she had dated back until April 13th, 2018. And that prejudgment interest, according to the case law, is a ministerial act that the court does after the court quantifies what that entitlement is and what that date of entitlement is. For example, some of the cases talk about if the date of entitlement on, for example, a support issue might be monthly, then you have to go back to each month of the entitlement from which to date that prejudgment interest calculation, and the relevance of that is you have to go back to that date of entitlement, which is the same date of valuation. And we had almost 3 years pass where she's not getting the benefit, where meanwhile, during this almost 3-year period, he's getting full benefit of this marital asset.
Does the word interest appear in the PMSA?
I don't believe it does.
Wouldn't it have been better to include it?
It may have, if I would have envisioned me standing here now answering these questions, for sure. But I think the case law is pretty clear that it does not have to be pleaded, and it is not something that it needs to be raised at trial.
Well, wait, let me stop you there.
Okay.
Because you may be right about pleading, even though I found an older first DCA case that said it had to be pleaded, but that's pre-Argonaut, so I know that was a game changer. But I do see some indications that you might want to let the court know that this is a feature of my claim. And you would agree that there was no mention of that at the trial of this case, the continuing hearings in this case, no mention in the pretrial, and it first bubbles up in the proposed order.
Correct, Your Honor. And I would, the proposed order, the intention of that was to present our respective positions to the trial court. So it was, in effect, a closing argument in the format of proposed final judgment. So that's where I would expect to take all of the facts and information that was presented in this 6-day trial and wrap it up for the court to make sense and to organize it in a way where the court makes appropriate findings as required by the various statutes that are applicable, and to pull in things like prejudgment interest, things that are ministerial acts, is how I read the case law, to make sure that the court hits all of the things that the court has to hit. Being a trial judge in a case that's complicated, it would be very easy for a trial court to miss those types of aspects. So I view our presentation of the proposed final judgment as the purpose was a closing argument. That was the appropriate time to bring that in.
Let's move back to the alimony award. What is this retroactive alimony award? As I read Chapter 61, there are 4 types of alimony that can be awarded post-dissolution: rehabilitative, durational, bridge the gap, and permanent. And this isn't the alimony pending suit. So when the judge awards, quote, retroactive alimony, shouldn't there be factors that are considered under at least one of these provisions before that award can be made?
Absolutely, and there are. There are 20-something pages of findings on factors on retroactive alimony. In fact, the entire prospective alimony is based upon the retroactive period for need. The court doesn't even allow any of the luxuries that these parties enjoyed during the marriage.
I understand the need and ability to pay analysis, but what type of alimony was being awarded in this retroactive alimony award? Because I can't find it anywhere in the final judgment. It's not
No, Your
labeled
Honor,
as durational. It's not labeled as permanent.
No, and I agree with Ms. Novi that I don't believe that a label is required. The case law permits, the court granted durational alimony, and the court is entitled or obligated to grant alimony retroactive to the date of filing, or in this instance, it wasn't the date of filing, it was when she got fired from her CEO position. But the court is under the case law, which I was not prepared to bring today, the court is required, if the facts support it, to retroactively provide support during the pendency of the action. And it doesn't have to be labeled necessarily, so long as there are appropriate findings. And those findings would be, did she have a need? And the court assessed the need and made many pages of findings about her need.
But you agree there's nothing in the statute that discusses retroactive alimony?
Nothing in the statute that says that?
Yeah, correct. Is there anything in Chapter 6108 that discusses the term retroactive alimony? Or, because you can find it in the child support provisions. There are all types of discussions within the statutes and provision for payment of retroactive child support. But in terms of retroactive alimony, is this simply something that's developed in case law, or is there other authority that you can
Your
point
Honor,
us
as
to?
I sit here, I cannot tell you whether or not retroactive alimony is mentioned in the statutes themselves. I can tell you, and I believe Ms. Novi agreed with me, that the case law is very clear that the court not only has the authority, but is required to retroactively provide support. And in that event, it saves interim alimony hearings and things such as that, because you know that you're accruing this entitlement if you have the appropriate facts.
Sure. And one other thing before we run out of time, the trial court did not impute any income from the investments from your client. Why isn't that reversible error?
Oh, that is reversible error, Your Honor. It's going to take me a little time, less than 44 seconds to get on that, but the main reason is because the burden of proof is on Mr. Iarussi, and he did not meet that burden of proof. And I could point you quickly to the Sikora case. In the Sikora case, the parties had agreed upon a rate of return for non-retirement assets, and then the party tried to apply that same rate to non-retirement assets. Or they agreed on it for non-retirement assets. They wanted to apply it to retirement assets without any other information, and the court said you can't do that. If you don't have a rate of return that's applicable to the class of assets, that's not competent substantial evidence. And what happened in this case is their expert that they called to testify took one subset of one targeted retirement account. I see I'm out of time. Do you want me to finish?
I'll extend your time by 30 seconds, yes.
Okay. He took one sub-account of one 401k that was a retirement targeted 2035 account, and he took that rate of return and he applied it to all of the non-qualified assets, all of the non-retirement assets, and the assets that haven't even been sold or quantified yet. So you can't, and he did no market research on any other of either the S&P as required by Sikora, or he did no research on the actual assets as she held them, or any other rates of return. And he also made his opinion based upon the fact that she would hold this in a long-term payment horizon. His testimony actually, if you look at it carefully, said if you had to pull income from this account, he wouldn't expect more than 2.5% to 2.5% of income from this account. And then if you look at the inflationary rate, which is required to be considered, that was at 2.3 the date of trial. So if you take a 1% investment gain off that, then you're not making income on that. So The short answer to your question is he didn't meet his burden of proof with competent substantial evidence.
Thank you, counsel.
Thank you.
And Madam Clerk, if you would extend the time for the appellant by an additional minute as well, please.
Thank you. Your Honors, the prejudgment interest issue that you discussed with Ms. Bailey is yet another indicator of an improper verbatim adoption by the trial court that it failed to exercise its independent decision-making authority. How was it to know? If you look at the Mathers case, even if you don't have to have a pleading, there have to be findings by the court with regard to increases in passive value and other equitable reasons for the award of that type of interest, and there's none of that. There's no reference to prejudgment interest anywhere, any place in the transcript. With regard to the alimony factors, none of those 20 pages of findings that Ms. Bailey referenced were drafted by the court. So despite the fact that the court made changes to the judgment with regard to the amount of alimony and the duration of alimony, it didn't make any other changes in that entire section about lifestyle and other things. And it bears noting, I think, that Ms. Michael, the former wife in this case, left the marriage with hundreds of thousands of dollars, and as a result of the partial marital settlement agreement, had $2.5 million. $1.7 million of that was liquid, and the court did not apply a cent of return on any of those assets. In rejecting the testimony of Mr. Popel, the court again reversed itself with regard to Daubert. It had rejected 2 times Daubert challenges to the testimony of Mr. Popel prior to the trial. It took the testimony of Mr. Popel, and it was only after it endorsed wholesale the findings as drafted by an advocate that it decided all of a sudden that Mr. Popel's testimony was not reliable and therefore not admissible. From the foundations of our democracy, to Justice Rehnquist in the Joyner case, to our legislature in its changes to 702, to this court, you cannot simply say, because I said so, it is so. And that's what Mr. Lugar did in arriving at his value on lobby tools, and that's what the wife invited the trial court to do. And in accepting that invitation, the court failed in its exercise of discretion. There is simply too great of an analytical gap between the court's own rulings and the proposed judgment adopted by the court long after the evidence was heard for this court to find that the court properly exercised its discretion. We would ask the court to reverse the retroactive alimony, reverse the prejudgment interest, to reverse the admission of Mr. Lugar's testimony and mandate the trial court to rescale equitable distribution consistent with the only evidence of value of lobby tools, that of Mr. Garcia, and to reevaluate need in consideration of all of the resources of the wife. Thank you.
Thank you, counsel. Thank you all. This court will stand in recess.
All rise.